Welcome everyone. We're just going to give it a moment for everyone to be allowed into the Zoom call, and then I'll do an introduction. So we'll just hang on for 30 seconds or so. Good. I think most people have joined us. So good afternoon and welcome to this Francis Taylor Building Public Law webinar on the topic today of Judicial Review Procedural Reforms. For those who don't know me, my name is Richard Honey. I'm a barrister at Francis Taylor Building. I'm chair of the Public Law Practice Group there, and I'm going to be chairing this webinar today. I'm very pleased to see that so many have booked and indeed logged in over lunchtime for this webinar today. You're probably all very familiar with Zoom webinars these days. We're going to try and keep it simple anyway in terms of the technology. We'll take questions through the Q&A function on the system, which you should be able to access by clicking on the icon at the bottom of your screen. The icon will appear when your cursor hovers over it. Please do feel free to type in questions or comments using the Q&A function as we go through. We'll try to answer questions in a block at the end after the talks, or at least as many as we've got time for. We're going to aim to stop at 2 o'clock or perhaps slightly afterwards. You've got questions that we haven't had time to get to. Please do feel free to email any one of us. Hopefully we've disabled the chat function. We're going to ignore it anyway. Similarly, the raising the hand function won't get you anywhere either today, so please use the Q&A function. All being well, we're going to be able to share our screens to show PowerPoint slides during the presentations, but we'll also email copies of the PowerPoint slides out afterwards. We are recording this webinar and are likely to publish it afterwards on the FDB YouTube channel for those people who are not able to join us today. So this webinar is going to consider two aspects of procedural reforms to judicial review. The first changes that are being introduced at the end of the month in the form of new practice directions to CPR Part 54. And that's going to cover a whole raft of things, including claim forms, pleadings, bundles, skeleton arguments, amendments, interventions, and various other things. Secondly, there's been an announcement of a Judicial Review Bill in the Queen's speech to implement changes to judicial review following the consultation which closed at the end of April. That consultation also covered various procedural changes, including time limits, the approach to grounds of resistance, and the procedure for intervention. Some of those look set to be quite important, especially, for example, the proposal to remove the promptness requirement, just giving a 3-month time limit for judicial reviews other than planning cases where we've got the 6-week time limit. But there are many cases that we three speakers deal with that are not subject to the 6-week time limit, so that will be important. So our aim in this webinar is to try to explain the changes which are coming at the end of the month, and then look forward to what further procedural reforms are likely to be implemented in the near future. We've got two speakers, Sarah Sackman and Charles Streeten. I'll introduce them both now. Sarah was called to the bar in 2008 and has a wide-ranging and successful public law practice. She's ranked as a leading junior in public planning and local government law, is a member of the Attorney General's B Panel of Counsel and the Equalities and Human Rights Commission Panel of Counsel as well. Has been recently involved in, for example, a judicial review of Birmingham street trading policy and defending judicial reviews seeking to quash a new parking zone on equalities grounds and seeking to quash parole board guidance as well. She's also involved in a number of electoral law cases, including the Coughlin case, the voter ID challenge, which is heading to the Supreme Court. Charles was called in 2013 and he's a member of the Attorney General's C Panel of Counsel to the Crown. He specialises in planning, environmental licensing, EU and public law. His recent cases have included judicial review of a grant by TfL of a private hire operator's license for a ride-hailing app, judicial reviews of the Mayor of London's street space plan and the TfL Bishopsgate traffic management order, and recently successfully challenged for Hackney Council, I think, an inspector's decision allowing conversion of an industrial warehouse into flats. So those are our two speakers, and we're going to hear first from Sarah. So I'll invite her to share her slides, and just a reminder to you all, please, if you've got questions or comments, please use the Q&A function on the system as we go. So Sarah, over to you.
Thanks very much, Richard, for that kind introduction. As Richard indicated, we're going to divide our talk into a couple of parts. First, dealing with the changes to the CPR Part 54, which take effect from the 31st of May, so just a few days in it, and then looking ahead in the second part of the talk to the judicial review changes and the proposals for change going through Parliament for announced in the Queen's speech. And before we turn to the first topic, I think it's fair to say that a lot of what we're going to cover today is going to be nuts and bolts, which many of you on this call will be familiar with. And much of what the changes to the CPR do, in my view, is set down what I think many of those of you who, I suppose, adhere to best practice are doing anyway. But it's important that it's now very clear and very clearly reflected in the CPR, such that if you don't follow the CPR rules and the practice direction, there are potential sanctions now, but also this is the way, as we sort of recap on what we already know, that I think we put ourselves, whether we're for claimants or for defendants, in the best possible position to ingratiate ourselves to the courts and present our cases in ways that the court is looking for and is going to best receive our arguments. So whether you're practicing on the solicitor side, barrister side, or instructing solicitors, this is useful stuff to be aware of, because this is what you want as a legal team to be delivering when you are acting for claimants and respondents in judicial review proceedings. So as I said, Part 54, the changes take effect on the 31st of May, and they're broken down into new practice directions, parts 54A, B, C, and D. D, the last one, dealing with planning court claims, no substantive changes there. So what we're really focusing on are mainly changes to the approach to claim forms and bundles, partly, as we'll see, catalysed, I think, by the pandemic arrangements, which has really catalysed, I think, the shift towards electronic bundles, and we'll say a little bit more about that in a second. Urgent applications and applications for interim relief, which Charles is going to touch on, and the issue around venue for judicial review. What are the objectives behind these reforms? Well, really two. The first, I think, is to make judicial review and the bringing of judicial review claims slightly more predictable and improving the fairness of proceedings. If we've got these new CPR procedural rules, we all know what rules we're playing by. And so that predictability, I think, is a really important element. And the second point, which is a theme running through practically everything we're going to talk about in relation to drafting of pleadings, preparation of bundles and all the rest of it, is to encourage parties and representatives to be concise. If I was to say there's one watchword of all of these procedural reforms, it's concision, and making claims and defences, for that matter, as focused as possible. I'm always reminded of the Mark Twain phrase, you know, I didn't have time to write you a short letter, so I've written you a long one. But I think that golden thread running through all that we do, whether it's bundle preparation, whether it's drafting statements of facts and grounds or summary grounds of defence, if we can be concise and focused, then we will be doing what these practice directions are seeking, and frankly, doing our clients a service, because that is what judges, busy judges, overloaded with all sorts of claims, will want to see. Claims and defences tightly focused on the legal issues at hand and keeping paper, whether it's electronic or hard copy, to an absolute minimum. So those are the two objectives behind the reform, which I think really inform everything that we're going to look at. As Richard said earlier, we will share these slides at the end of the presentation, so there's no need to take all of this down. But I should add that there is absolutely no substitute for actually going and reading the practice direction. What we've provided here really is a compressed version of that. But let's start at the beginning of our judicial review, our claim form and our statement of facts and grounds. Claim forms must set out all material facts. They must refer to relevant statutory provisions and set out whether any alternative appeal mechanisms that exist have been and could have been used. Because of course, judicial review is a remedy of last resort. We get a reminder in the practice direction that the claim form must be clear, it must be concise, and it should contain both a statement of facts and grounds. Typically, but it doesn't have to be this way, they can be produced in a single document. Certainly that's my practice, to put the statement of facts and grounds in a single document. And the practice direction tells us that should be no more than 40 pages. And if you can keep it to a good deal less than that, so much the better. We're instructed by the practice direction to identify each ground of challenge, identify the relevant provision or legal principle which is said to have been breached, and provide sufficient detail to enable both the parties, the respondent and the court, to identify what are the essential issues that need to be determined. And bear in mind, put yourself in the shoes through all of this, in the shoes of the judge who is determining this. He or she will get possibly a permission list with between 5 and 10 paper applications. Yours will be one of many of them. And they've got to glean pretty quickly from your claim form, from your statement of facts and grounds, what the essential issues are. So help them to do that. That's what this practice direction is designed to do. Speaking personally, my practice is to put a summary of what the grounds are right up front of the statement of facts and grounds, before then getting into a more detailed factual background and legal framework and all of that. Others tend to do, others may do it differently. But the other point to remember is state precisely what relief you're seeking. Are you seeking a declaration? Are you seeking a quashing order? Are you seeking relief beyond that? Set that out. Tell the court exactly what you're asking them for, so that when that busy permission list judge comes to look at your claim, they can quickly get to the heart of the matter. I've set out there Rule 4.4, what the claim form needs to be accompanied by. Again, this will be familiar to those on the call, particularly those who do claimant work and find themselves making the running, if you like, in judicial review. And there's a lot of front-loaded work that needs to be done in identifying any written evidence in support of the claim, providing the court with copies of any orders that the claimant is seeking to have quashed. If what you're seeking to have quashed is the decision of a court or tribunal, that's got to be included. You'll see subparagraph G in that list of things you've got to put together with the claim form, reference to copies of any relevant statutory material. I highlight that because I've seen mixed practice. I've seen some solicitors pull together bundles where the statutory materials, and again, that's not entire acts, that's the extracts with the provisions, the statutory provisions that your claim relates to. But I've seen solicitors put that in, I've seen them leave them out. Here we've got clarity that statutory material should be provided with the claim form. And a list of essential documents for advanced reading by the courts with page references. Again, help the judge, help him or her get to the heart of the matter by focusing on those key documents which are germane to your claim. So that list of essential documents needs to be in there now with the claim form. So that's the claimant's side. Then the focus switches to the defendants and acknowledgement of service. Again, the emphasis is on succinctness, on concision. The amount of times the word concise or succinct appears in the practice direction 54A. Well, I should have done a word count, but it's a lot. And again, in your acknowledgement of service and in your summary grounds of defence, identify the relevant facts, provide a brief summary, succinctly explain the legal basis of the response, and be as concise as possible. And here we're told 30 pages max, and usually significantly shorter. For my part, when I'm acting for respondents, typically for government legal department or local authorities, I'd say a lot shorter than 30 pages, not least because if it's taking you 30 pages to explain why a claim is unarguable, it rather suggests the opposite. So, you know, if you can keep it short and snappy, that's not to say, you know, don't engage with the claimant's arguments in a genuine way. Of course you must, but keep it short and focused, because again, that hard-pressed permissionless judge has got a lot to read, and if you can, instruct your barrister to keep it to 10, 11 pages, that should be sufficient to explain why a claim is unarguable. So it not only complies with the practice direction, but I think it has a presentational advantage in demonstrating that the argument really can be rebutted pretty easily. We're given some guidance in terms of the approach to renewed applications for permission. So this is in a scenario where permission has been refused on the papers by my busy permissionless judge, and we're going to have another bite at the cherry, because those of you who act for the claimant side know many a great victory was declared unarguable right at the start of the judicial review process. So don't give up at the first hurdle. Just because one judge says your case is unarguable doesn't mean it is. And once you get it in front of a judge at a substantive hearing, they may take a rather different view. But that being the case, it's really important when you're renewing an application for permission to focus on the purpose of the request to reconsider. And we're told by the practice direction that there's a need to identify the scope of the renewed application and to specifically address the reasons given by the judge who has determined the paper application, to address those reasons and say why they're wrong. And again, I've seen mixed practice on this. Some advocates do that in a renewed application for permission, and some just ignore completely what the previous permission judge has said. And here we're told at Rule 7.6 that there is a need to grapple with what those reasons are. Bear in mind that standard hearings on renewed applications are 30 minutes and are supposed to include judgment. Now, we all have experience, I suspect, of permission hearings that go on a whole lot longer. I've seen permission hearings that last a whole morning, even a day. Again, should it take a day to decide that something's unarguable? That's a question mark. But we are reminded here that a standard hearing will be 30 minutes, including judgment. And that's not a very long time. And certainly if you're up in the planning court in front of certain judges, they will stick to that. And you know, we're reminded of that here. So if you think that longer is required, you need to apply for that time and justify why you say that additional time is needed. The practice direction reminds us that neither defendants nor interested parties need to attend renewed applications for permission. And I often get asked by public bodies, do we need to go? Do we need to show up? You don't need to. And as I say there, you won't generally get your costs for doing so. But if you don't, in my view, I think that puts you at a disadvantage because whilst the hearings are short and one can assume that the judge is familiar with the issues and will interrogate the claimant's advocate, I think if you want to make sure you know what happened at that permission hearing and make sure that certain arguments are rebutted, you need to be there. So generally speaking, my advice would be that although it's not necessary for you to be there, although you can expect that you may not be called on to say very much, given the tightness of time, if it is possible and resources permit, my advice would be to ensure your barrister, and if not your entire legal team, be there. I don't know if others take a different view, but that's my general advice. So the claim gets permission, and we move on to the whole issue of detailed grounds of defence. We're told in the practice direction that defendants can rely on the summary grounds of defence. And indeed, I've seen that a lot. And if you've put in good, robust, fairly full summary grounds of defence, there's no need to file separate detailed grounds. Again, we're reminded to be concise, and we're told that detailed grounds shouldn't exceed 40 pages this time. Thinking ahead, and we'll come in a second to what the practice direction says about skeletons, but skeletons, we're told, should be kept to 25 pages. So skeletons, going back to their original nomenclature, skeletons are supposed to be skeletal, they're supposed to be punchy and get to the heart of the matter. And we've all had experience of judicial reviews where the issues get refined and sometimes narrowed as one goes through the proceedings. And so by the time you get to the skeletons, you can be perhaps more focused than you were right at the start when pleading the claim or even defending it, depending on how the timing of when it was filed and what documents were emerging and all the rest of it. But given, again, the emphasis on concision in the skeleton, if there is stuff that you have not covered in your summary grounds of defence, then use the opportunity to elaborate in the detailed grounds of defence if you need to. But if you don't, again, it's another document you can do without. There is a reminder in the practice direction in relation to defendants' duty of candour and the requirement that detailed grounds should identify all relevant facts and reasoning. But as I say there in the slide, that the duty of candour is a continuing duty on all parties. So it's not as if that applies solely to the preparation of detailed grounds of defence, and the expectation is that one will have treated the acknowledgement of service stage in exactly the same way at complying with the duty of candour to provide all relevant materials, helpful or unhelpful to your case, to the court. Amending grounds. So you put in your grounds and then you realise, there's this other point we should have taken but didn't, or it's become apparent that that new grounds need to be added. You can only do so with permission, and you've got to apply for that permission in line with Part 23 of the CPR. So you've got to give notice, you've got to serve any application 3 days before. You've got to apply promptly and explain why you need to make the amendment and why, if there has been delay, why that delay has arisen. Why was this ground not identified in a timely fashion right at the start? But provided you set that out, the court will consider that application and any argument for why the amendment should be resisted. Generally speaking, I would advise claimants to seek the agreement of the other side in advance, because if that agreement can be sought, then that smooths the path to getting the grounds amended. If not, you're going to have to apply and see how matters play out. Once the grounds are amended, if they are amended, at that stage, the court can then give additional directions to the parties, including the defendant, to amend detailed grounds to respond to any amended grounds. But that's the process for that. So we're reminded about that. We're also given a reminder as to the role played by intervenors and how they can involve themselves in judicial review proceedings. Those of you who've acted for intervenors, whether that's NGOs or other sorts of parties, public bodies with an interest in particular cases, you will know, but it's a useful reminder that you need permission to intervene, and your application again must be prompt, the court is unlikely to accede to an application to intervene if the effect of that application would be to delay the proceedings involving the main parties. In that application, you need to explain who you are, and you need to explain why and in what form you wish to participate in the hearing. Think carefully about whether an intervention can be done in writing alone and whether written representations would suffice, or whether your client want to make sure they're at the hearing. Ultimately, it would be a matter for the court, which they allow, but it may be that if you frame your application as being purely on the basis of written representations, that a court will be more likely to accede to that. It completely depends on the case, but your application is going to need to include a summary of the representations that you propose to make, and seek permission for serving any evidence that you may wish to make. And often interveners, particularly where for a public body or an NGO, that can bring that sort of breadth or that different perspective, because normally that is why an intervention is, for want of a better phrase, adds value, if you like, adds something to the proceedings, adds to the arguments that are already being advanced by the main parties. There may be a desire to serve additional evidence, expert evidence, and you'll need to seek permission for that. Again, if you look at the last bullet point, where possible, I'd advise seeking the consent of the other parties, the claimant and the defendant, to putting that in. If they consent to your intervention, which may be to their advantage or not, may simply be neutral, then so much the better. You can put that before the court and explain that you have their consent. And the effect of that may be to avoid a hearing at which, you know, case management directions and all the rest of it will need to be addressed. So that's interveners. And then we come to skeletons. So we're limbering up for our substantive hearing. We've made it through the permission stage. We've exchanged pleadings. We've amended our grounds, and we are racing towards the substantive hearing. The practice direction reminds us, what is the purpose of a skeleton argument? I think the clue is in the name. I think when the Wolf reforms came in, and when Judicial Review began to formalise in the way that it has done over the last 20, 30 years, the idea of the skeleton was to provide a pithy encapsulation of a particular party's argument in order to assist the court. And we've all been involved in cases, whether we're sometimes guilty of it ourselves or not, where we've confronted copious reams and reams and reams of material purporting to be a skeleton. It's, you know, the sort of chubbiest skeleton on in history, and that's not going to assist the court. A very baggy, wordy skeleton, which is not self-contained, which cross-refers to other documents but doesn't necessarily cohere in its own terms, that's just not going to cut it. So we're reminded here, purpose of a skeleton argument, to assist the court by setting out, again that word, as concisely as practicable, the arguments upon which a party intends to rely. And we're reminded here, 25-page limit. And I think that will come as a disciplining function to a number of advocates and their teams. Skeletons should define and confine the issues, be cross-referenced, and as I said, self-contained, shouldn't contain extensive quotes either from the underlying substantive materials or from legal materials. Clearly identify authorities, don't have long lists. You know, you don't need 3 cases to make good one proposition, if one will do. And then the threat of sanctions. So skeletons will be returned if they're not compliant, and costs disallowed. So, you know, putting in a 30-page skeleton is not going to work. You've got to make sure that you and your team have time to write that short letter, because you're not going to get away with putting in a long one. And skeletons, unless there is a specific bespoke timetable, and we'll come on to urgent applications and urgent hearings in a moment, but on a general standard directions, claimants need to put in their skeleton 21 days before the hearing, and it's 14 days for the defendant. We come to bundles, and this is where I really feel like I'm, it's not, I won't say preaching to the choir, that's not quite right. I'm lecturing the experts when it's really all of you that are much better versed than we are when it comes to bundles. But we all know how critical bundles are. And actually, the more that one can start the bundle preparation process as soon as possible and front load that, the better. The more that it's a team effort, the better, because that is going to assist in working out what exactly must go in to a bundle and what, quite frankly, can be left out. How to prune that bundle down to the bare essentials so that solicitors are not left at the last minute having to cobble together and paginate and do all the technical stuff, but that can be done long in advance, and then that can be then reflected in cross-reference skeletons and all the rest of it. So parties shall agree and lodge a hearing bundle, paginated and indexed, containing all the relevant documents for hearing 21 days before the hearing. So that's the same day as the claimant's skeleton. As I said, that really emphasises the need to front load and any preparation, because it's going to have to go in on the same day as the skeleton, which will be cross-referenced to that hearing bundle. If your main hearing bundle is 400 plus pages, then a core bundle is required. I remember I was sharing this story earlier with Richard before we came on the call, that when I started out in practice, someone said to me, imagine that, world weary judge who's going away for the weekend and has got to take a bunch of papers home with him or her to read over the weekend. If you provide them with 600, 700 pages worth of material and a core bundle, even before they've, opened up that hearing bundle, they're already sort of exasperated with the parties. So really thinking hard in conformity with the practice direction about how to pare down those bundles. And it is time consuming. It's actually much harder to produce a short bundle with just the extracts, just what's really needed, particularly where that has to be agreed and there may be a bit of back and forth in the parties. That takes a lot of time, but it's so well worth doing, because it will just improve the impression on the court, and it will also, I think, ultimately facilitate the hearing. Solicitors for all parties have to certify that the bundle meets the requirements, so that needs to be done. And 7 days before the hearing, parties must agree and lodge an authorities bundle, as well as an agreed list of issues, a chronology, and an essential reading list and time estimates. A lot of that used to be included in the parties' skeleton, where barristers remembered to do it. Now that's got to be put in 7 days before the hearing. And there is a requirement for a hard copy and for an electronic bundle. And where you're in the divisional court, that means one set for each judge. I think this is obviously something that has been, as I said earlier, catalysed by the effects of the pandemic and moving to remote hearings. We understand, and Richard, on behalf of FTB, attends the admin court users group, where you get a lot of the kind of intel on the nuts and bolts of how this procedural stuff is working. We understand, and it's generally been my experience, that the courts take a pragmatic approach to bundles. So if, as inevitably with some cases, one is working down to the wire, contact court officers, particularly if your case is not being heard in the London admin court, but in one of the regional branches of the admin court. Contact the court office in advance and explain that an e-bundle will be filed by the deadline with hard copies to follow, and set out when that's going to be done by. I think the courts, acknowledge the practical realities of running these cases, and I think provided you're in that dialogue with the court officers, then the courts will generally take a pragmatic approach. But all of this is presaging a time where I think we move to electronic filing only. And again, I'm conscious of the fact that those on the call will be so much better, not least because you're responsible at pulling together these bundles in practice. But I think we've all learnt an awful lot over the last 18 months in terms of what's required. But I would draw your attention, it's not on the slide, but the Administrative Court Office has produced further guidance in addition to Practice Direction 54A on what is entailed by electronic bundles in terms of their size, in terms of the software and the PDF, in terms of the requirements on hyperlinking, indexing, pagination. It's all pretty prescriptive stuff. And again, I know it'd be familiar, but it's worth having there as a checklist. There's also quite a helpful bullet point about, well, what do you do when you realise that there's that one document that didn't make it into the original hearing bundle? That's always the one that throws me. Where should that go? And what the guidance says is that inquiries should be made of the judge hearing the case as to what the judge would like to do about it. So rather than trying to upload a fresh bundle with the documents added, whether at the end or inserted at an appropriate place, check with the judge how they would like to do it, because it may be, and we're told in the guidance, they've already started marking up their copy or working on it. And actually that causes more havoc than it does good. And we're told that absent a particular direction, any pages to be added to a bundle as originally filed should be provided separately in a separate document with the pages appropriately subnumbered. So it may be that you just got to keep it separate. So there's lots of useful stuff in the ACO guidance on bundles. Also some interesting guidance on for litigants in person, but I suppose for this audience, more particularly, what do you do when you're faced with a litigant in person who may be struggling with some of these requirements around hyperlinking and bookmarking in a sidebar, the different documents. In those circumstances, although it is the claimant's job to, as we know, make the running when it comes to these things, what can one do as professionals if one is in the position of being a respondent or an interested party to facilitate that process? Because ultimately, we're all going to have to argue, one is going to have to argue the case in court, and it's going to be much more difficult to do with the new ways of working if the bundles haven't been properly prepared. We're almost getting to Charles. Just one more point for me from the practice direction, which is as to agreed, it should be agreed final order. If, notwithstanding all your brilliant preparation and perfectly formed, succinct skeleton arguments, if prior to judgment the parties are actually able to agree the terms of a final order, then it's for the claimant to file 3 copies of any draft order that's been agreed. And that should be accompanied by a short agreed statement of the reasons why agreement has been reached, along with any legal materials relied on. Draft orders and the agreed statement must both be signed by all the parties to a claim. And the reason why it's necessary to provide that statement of reasons and legal materials is that ultimately, notwithstanding the agreement between the parties, it's for the court to make the order if it is satisfied that the order should be made. And if there are outstanding issues or things which concern the court, then a hearing will be set. So really important, not just to sort of bung in a consent order, but to actually explain the basis for that order. And that is all set out at Rule 16. And so then we turn away from 54A to Practice Direction 54B. And with that, I hand over to Charles.
Thank you very much indeed, Sarah. I just wanted to pick up on a couple of things that Sarah had said going through there from my own experience. So the first of those was when Sarah was talking about concision in claim forms, and the practice direction says maximum 40 pages, and Sarah said very many fewer pages than that are likely to be required. I couldn't agree more with that. And I think one of the big bugbears of judges is to see passages of text often taken out of context, copied into a statement of facts and grounds. What they really want to see is as short a document as possible with cross-references to the relevant documents, and then an essential reading list. And I think if you can do that, your judge with that pile of permission papers is going to be so much more willing to grant permission to the claimant, because they're going to be able to follow the argument rather than wading through reams of text that they're not interested in. and then hopefully grant you your permission. Similarly, with summary grounds, I agree entirely with what Sarah said, that there's just no need for really prolix summary grounds. I think 10 pages, as Sarah said, is almost always going to be sufficient. And I mean, you see how short judges' permission refusals are. They tend to be a page and a half max. They're able entirely to dispose of the claim in that page or page and a half. So how you can possibly require 30 pages to give your knockout blows, I think it's difficult to understand. And one of the ways I think to do that is not to mess around with putting reams and reams of disagreement about particular facts in your summary grounds. If there are going to be factual disputes, then you can do that in your detail grounds. But at the summary ground stage, you want to avoid any suggestion of factual dispute and just hammer home your knockout blows. And then finally, and this really brings me on to what I'm going to talk about in relation to urgent applications, the importance of procedural rigor in judicial review is very much, I think, increasing. And that's why we see these changes to the practice direction. The Dolan case has made clear that evolving judicial review just is not appropriate. And it's not the way that the court wants the administrative court to run. It wants it to run essentially in the same way as the rest of the QBD. And there seems, I often find, to be a real reticence to use N244s and interim procedural applications in judicial reviews. I don't really understand why, because I think actually tactically they can often be the most useful thing both for claimants and defendants. If you need to take a point arising from the defendant's grounds, either summary or detailed, then apply to amend your grounds, explain to the court that your application to amend arises from something they've said, and the prospects of you not getting permission to do that in circumstances where you've got a good point and there's many, many months or at least many, many weeks before the case is going to reach a final hearing is almost none. If you then try and raise that point without making the application at the final hearing, the prospects of the court allowing you to amend are very much slimmer because they're terrified of some sort of injustice being caused to the defendant. So I think using applications properly, as frankly one would expect in the QBD, is one of the things that the court is really pushing for. And I think, as Sarah says, one of the reasons why we have these changes is because of the rise of the e-bundle. And another is because of the judgment of the court in Dolan, which has made clear that judicial review needs to have the same level of procedural rigor as private law litigation. And I think nowhere is that more apparent than in urgent applications. Those can be made to the administrative court, as the slide says, between 10 a.m. and 4:30. If you need it outside of those hours, then you need to go to the urgents judge in the QBD list, who's there potentially at the end of the phone all night. The way in which you make the application is in the N463, and perhaps one of the most important things when you're applying for urgent consideration is explaining why you have sought urgency. And there are two kinds of urgent application. One of them is where you're seeking urgent consideration. That essentially means some sort of truncation. And the other is where you're seeking immediate consideration. That means you want this looked at now and certainly within the next 3 days. And you specify in the form the amount of time that you want to pass before a judge looks at the papers, and the court will keep to the time that you have requested. You've paid an extra fee for it, and those papers are going to go in front of a judge that soon. But I think there is probably something of a tendency amongst claimants in particular, and I've certainly found this myself, to think, well, I want an answer now, so I'm going to ask for this to go in front of a judge in 2 hours. The trouble with that is that you're essentially then giving the defendant almost no opportunity to respond, and the duty the court is going to impose upon you in those circumstances, the extent to which it's going to expect you to do the defendant's job for it, is so much higher, and it will be so much more furious with you if you have failed to draw the court's attention to something that's material to your application. And so generally, I think if there's time available, then make your application on notice, not necessarily full notice, but give the defendant 1-2 days to make its application. Certainly, when you bring your application, and this is the bottom point on the slide, you need to make sure that anything that the defendant has said to you goes before the court in the form of inter partes correspondence before the application. There's almost no circumstance imaginable where you can't tell a public authority, at least with a couple of hours notice, that you are about to lodge a claim. And it's almost always going to be the case that the public authority will send you some form of response by email or in a letter. There was a case I did for Kensington a couple of years ago now, where we'd been in correspondence with the claimant who was indicating they were going to seek urgent interim relief for about 7 days. They then did suddenly bring their claim, slightly unprompted, shall we say. They'd said, we're going to go, we're going to go, we're going to go. And then without telling us they were going, they went. And they didn't include any of the inter partes correspondence in the bundle that they sent to court. The order was made on that ex parte basis. And when I turned up to court on an application to vary or discharge the interim relief, it couldn't have been an easier job for me, because all I really needed to say to the judge was, well, the judge who imposed this order hadn't seen any of the correspondence that my client had presented. They, for whatever reason, were not given the reasons why these grounds we say are unarguable. In fact, they are, and the court very much had time for that. And that resulted in the matter moving both at interim and at final stages very much in my client's favour. It just turned the court against the lack of candour that had been shown by the claimant. It's worth noting, Sarah, if we could have the next slide now, please, that these applications are not only made by claimants, they're also made by defendants. And indeed, in a very recent case I did called Keir against Natural England, which was in the High Court earlier this month, I think, or no, just at the back end of last month. And we managed to move through the whole of a High Court procedure in about a week, with a full final hearing on the Friday, which meant almost no one slept during that week. We'd got an interim injunction from Mrs. Justice Lang on notice with exchanges of pleadings prior to that. HS2 were unhappy with that. They applied urgently, or indeed immediately, to vary or discharge, and everything was called into court. And it was HS2 who had made that application for immediate consideration that brought the case into court. And when they'd done that, there were various things which they'd not referred to in their application when they put their grounds. And as a result of that, there were points that I was able to make which didn't necessarily cast their conduct in the best of lights. And that just makes it more of an uphill struggle. So if there's one thing that I can emphasize, it's the points on this slide, which is that firstly, you need to explain very clearly what you're seeking and why. Secondly, that you need to take reasonable steps to investigate what's material to that. So that doesn't mean you can just say, oh, well, I don't know about this, and so I haven't brought it to the court's attention. It is your job as a party and as a solicitor acting for that party to go out and to find the documents which may undermine your case. Obviously, if you've asked the public authority for them, if they've not been provided, you can tell the court that, but you're under a duty to do that and to say with evidence what you have done in relation to doing that. And then finally, and perhaps the most important thing of all, is that you must identify, one, all of the evidence relevant, whether it helps you or harms you, and two, you must identify all of the arguments that may or may not help or harm you. You need to present your application, if you're going essentially ex parte on any urgent application, as fairly as possible. The court will have a lot more time for an applicant who has come to court and said, this is my approach to this. I think I deserve the relief, but I accept that these are the arguments against me, than someone who comes to court, bullies, for want of a better word, the court into giving it interim relief, and then when there's an application to vary or discharge that relief, a whole load of things that were never referred to come out of the woodwork, and the judge feels like they were pulled the wool over. That is the worst possible circumstance, I think, for a claimant. So seriously, when you make these applications, comply with that duty. Sarah, if we could now move on to the next slide. One of the things that you quite often see included with urgent cases are applications for expedition. The real reason why you'll get those are either because interim relief has been imposed, in which case the prima facie valid decision of a public authority has been suspended, and the court would like that to be the case for as short a period as possible, or because interim relief has not been granted, but that in order to avoid the claim being rendered academic, it's important that the decision is taken by a particular date. And I mean, I remember my very first judicial review that I ever did in the High Court was against Richard, where I got an urgent interim injunction in relation to some trees in Sheffield, quite a lot of trees in Sheffield. And we had that case expedited, and Richard succeeded at the final hearing, unfortunately for my client. But on that final day, having had an expedited hearing and an injunction in place pending that, the injunction was then discharged pending a judgment which came out a number of weeks later. So the court will expedite these cases where it thinks doing that is the best way to achieve justice. But it's really important, again, that you explain in clear and concise terms why you are seeking expedition. And in particular, you need to explain why you have delayed and then sought expedition. So an example of that I have running at the moment is, and this is public knowledge, that Uber have brought Part 8 proceedings seeking a declaration as to the appropriate operating model in light of the Supreme Court's judgment in the Uber and Aslam case. And they've sought to expedite that. So they've applied to the court, as one of the authorities puts it, to skip the queue. But they applied for that last week. And Uber and Aslam was a case in which the Supreme Court handed down its judgment in February. And it's very difficult to see why, having sat on your hands since February, you should come to court in May and say, we court need you to jump into action and decide this, within the next fortnight. It's very difficult to understand how an application to expedite can be justified where there's been delay. It just creates the wrong impression with the court. So if you're going to expedite, you need to move with as much alacrity as possible. Final point to make here is that there are other procedural applications that you can make, either in your claim form or in your summary grounds of resistance, or using an N244. And again, I think probably procedural applications are underused in judicial review, but one of the cases I was involved in was the We Love Hackney case, where my client Hackney, permission for judicial review was granted against us. We sought an order for security for cost, and that order for security is what ended up determining the litigation, because following a contested hearing, security was ordered, not paid by the claimant, and the claim was struck out. And so I think it is important just to remember that those other applications, which should include either in your claim form or in your acknowledgement of service, or which you can make separately, are actually capable of determining the course, even in public law litigation. Thank you very much, Sarah. Next slide, please. And I think we're back to you now, aren't we?
Really briefly, back to the issue of venues and Practice Direction 54C. This is a very short point, really, which continues with a theme which I think has been running for some time now, and arguably, rightly so, which is the emphasis on the sort of regionalisation, if you like, of the admin court, and the general expectation that proceedings will be heard in the region where with which the claim is most closely connected. And I emphasise there, it's the region with which the claim is most closely connected, rather than any other factor. I mean, the court will have regard to the subject matter of the claim and where the claimant and defendants are based and where their legal teams are based, but that's not going to be determinative. And some of us may have experienced that, in the last few months, Richard mentioned the case that I brought on behalf of a group of street traders in Birmingham, challenging Birmingham City Council's new policy regulating street trading there. And, I conducted that hearing on behalf of my clients remotely, based in London, in the Birmingham High Court. But as we move increasingly back towards in-person hearings, which I think we are set to see the return of in a big way, it's already beginning to happen, and subject to the relaxation of the lockdown rules and how things pan out with the pandemic, we should expect that whilst remote hearings may be retained for certain case management hearings and that sort of thing, that in terms of substantive hearings, both permission hearings and full hearings, that we can expect to return to in-person hearings. And in that vein, the venue of the hearing is going to matter in terms of the practicalities of those of us in practice. So we should expect that if a claim is closely connected to Yorkshire, that the case will be heard in the Leeds admin court, and so on. So a reminder of that theme of regionalisation. In terms of how things are currently working, all of us will have different experiences, but as we sort of emerge from the pandemic, just a couple of reflections. One, that the courts have noted a slight slowdown, this is a short-term thing, of course, a slight slowdown in the pace and rate at which permission paper decisions are being dealt with, and that's partly due to the need to redeploy High Court, admin court judges to deal with the significant backlog of criminal cases that built up during the lockdown period. But as I said, subject to that lockdown easing, we should see an increasing shift back to hearings in person, which will be nice because we'll get to see all of you in person and be able to work together in that way. But in the interim period, as we're in this interim period, and there will be some people who need to continue to shield and what have you, it will be a judge-led decision. So the judge responsible for hearing the case may invite parties to give their views in advance. So if there are reasons why you, clients, cannot appear in person, then set that out in writing well in advance, send your views through to the judge hearing the case. And it may be that now the courts have shown that they can successfully, fairly and properly hear high court, admin court cases of the highest significance and sometimes controversy remotely successfully. We know that that is available. So we should expect more in-person hearings, but because we know that remote hearings are available, that provided there's a good reason why a hearing should be heard remotely, there's no reason why that can't be conveyed to the judge, and the judge will decide whether that's appropriate. Now, handing back to you, Charles, for a few words on the Judicial Review Bill.
Thanks very much, Sarah. Again, just picking up on a couple of the things you've talked about, and in particular the concept of regionalisation of judicial review. I think often that's quite a tactical decision, or it certainly used to be, because as a claimant, having a circuit judge sitting as a deputy high court judge might mean you've got a more favourable permission decision, certainly, just because they're less familiar and robust with the law. But I think that that's becoming increasingly difficult to try to remove a case as a defendant from a circuit judge's remit. And one of the ways that one used to do it is talk about specialisation, but I think the court is really moving towards sending specialist judges up to regional centres to hear these cases. And I can think of two examples of that. One is a case I did in relation to Liverpool, where we ended up sitting in Manchester, so the Centre for the Northwest, with all counsel and the judge as well, having come up from London on the train to sit regionally. And whilst that might have seemed an odd decision, it was absolutely the right decision, because many, many local people were interested, and they all travelled to Manchester, whereas they may not have travelled to London to watch it. So with the loss of remote technology, I think the importance of regionalisation is going very much to remain. And I actually also am reminded of a case I did in the Court of Appeal about taxis in Wakefield, where the Court of Appeal, because it was of local interest, sat, including the Master of the Rolls who came up from London, in Leeds as a regional centre. So I think we are seeing increasing regionalisation. Therefore, if as a defendant you're very keen to ensure that you do not get a circuit judge determining a permission decision because it's an important case for one reason or another, you need to think about having it put into a specialist list if you can. So in planning, for example, significant planning court claims are only dealt with by full High Court judges with particular experience of planning matters. And so if you can take it out of the general run, even if it's still in the regional centre, it will be dealt with by a judge with that experience. So I think just tactically, the regional centres actually raise a number of issues that both claimants and defendants want to be thinking about. Moving then from that more nuts and boltsy practical side of this presentation to the crystal ball gazing for the Judicial Review Bill and procedural changes. And I'm going to try and invite Sarah to talk about some of this with me as we go, just because we are crystal ball gazing. In terms of what's proposed in the bill itself, the one thing that I'm certain will appear in the bill will be a reversal of CART JR. So CART JRs are essentially judicial reviews of refusal of permission by the upper tribunal. They're named after a Supreme Court case called CART, unsurprisingly, in which the court said that such decisions were amenable to judicial review by the High Court. I know that one of the things that Alba is particularly bothered by in relation to that proposal is that the numbers presented by the government in support of removing CART JR are, shall we say, spurious. So the way in which they've put together their, and I can't remember exactly the figure, I think it's about 0.2% success rate figure, is to look on Westlaw at the number of decided cases where there's success, and then to compare that with the number of claims brought, and said, oh, well, there's only 2 reported judgments of success, and there's X number of thousand cases brought a year, so the success rate is 0.2%. But what that fails to take into account is that a very great number of these cases are not reported cases, because if there's a overturn of permission, there'll be no reported judgment. The matter will simply be returned to the upper tribunal. So I do think that there's a serious presentational issue with the way the government's considered that. And I don't know what your view is, Sarah, but I think there's every chance of a bit of a political clash over JR once it goes up to the House of Lords, at least.
Perhaps, although the government also has a pretty large majority, so I'm very confident it will get its reforms through. Charles, I don't want to stop you, but I am conscious that we must make sure our audience have time to answer questions on the procedural stuff. So I think we need to sort of rattle through the next couple of slides. We have time for that.
I think I can do that fairly swiftly because we've covered a lot of this in a previous webinar. So if you want to see it, you can go on YouTube. But the first thing to mention are suspended quashing orders. These, again, I think are very likely to appear in the bill. What they essentially mean is that where the High Court has formed the view that a decision is unlawful, it makes a decision that the decision actual failing to act under question is quashed pending some further step. If the further step is taken, then no quashing order will be issued. Next slide, please, Sarah. Then there are 2 points which I think are less likely to appear in the bill, but not impossible. One of them is nullity. My own view is that legislating over nullity is, well, frankly, an absurdity. I don't really see how it's going to achieve anything. The concept of nullity in judicial review is now well understood and, frankly, of limited application. I don't really see things changing. I think perhaps that's something which has found its way into the consultation document because of the involvement of academics over practitioners. And then secondly, ouster clauses. If there's one thing I'm worried about, it's ouster clauses in this form finding their way into the bill. If they do, that is, in my own personal view, and I really emphasize that, it's only my view, a serious affront to the powers of the judiciary to control decisions made by the executive. And you see, I put on the slide the way in which that's justified. They say that it would be better to achieve accountability through collaborative and conciliatory political means rather than the zero-sum adversarial means of the courts. What that actually means is where we've done something really bad, we don't want the courts to be able to overturn it. That is, in my view, seriously constitutionally concerning. Next slide, please, Sarah. And then finally, there's a series of procedural reforms proposed. I have a bet on with Richard of £10 that none of these will find their way into the bill, but that they might find their way into subsequent changes to the CPR. I think fairly said it's probably a toss of a coin whether they do. I will run through them very quickly. Firstly, changes to time limits, the removal of the promptitude requirement. I think that is very likely to happen. My own view is that it's a good thing. It will bring clarity, and then people will be able to apply for extensions of time where required. Secondly, agreements to extend time to encourage pre-action resolution. I think that's very unlikely to happen. It's described in the consultation document as undesirable, and I agree with that because it will just result in protracted pre-action correspondence. Finally, the concept of a track system for judicial review, so essentially having significant and non-significant claims, rather like the fast track and the small claims track and the multi-track in part 7. I think that might happen, and I don't think that there would be a problem with it happening. Intervenors, there's potentially going to be an introduction of identifying wider groups that will assist. I don't think that will happen, mostly because I think it will add procedural complexity, and I don't think anyone's keen to do that. Replies a formal stage after the grant, before the grant of permission. I think that will happen. I think that's sensible. I think people do it all the time anyway. And I think as judicial review has evolved, people often need to rebut what's said in the more detailed summary grounds that are provided. So I think that will be helpful and that will happen. And finally, no requirement for summary grounds if the pre-action protocol is followed. That might happen, but I don't think it will make any difference because I can almost guarantee all defendants will still put summary grounds in. So that's my rundown of the proposed procedural reforms in what I hope is about 2 minutes. Yes.
Brilliant. Thank you very much indeed, Sarah and Charles. Sarah, if you could stop sharing your screen now, we can all come on. And I'd like to make sure we deal with a couple of questions at least. So one for you, Sarah, first, perhaps, which is you mentioned that there are going to be sanctions for not complying with the practice direction in relation to skeleton arguments, I think. But there are various other requirements as to what apply now as new restrictions for statements of facts and grounds, summary grounds defense, bundles, etc. What's the position in relation to enforcement or sanction of those? And do you think in practice opposing parties are going to be making complaints about these things?
Yeah, Richard, it's a good question. I mean, you're absolutely right. I mean, in relation to skeleton arguments, as I said, very specific. if essentially a skeleton can be excluded on the basis that it's not compliant, and or the party putting in a non-compliant skeleton can be hit in costs, and effectively, barred from claiming costs of producing that document and having to respond to it and what have you. And although that same sort of prescription for sanctions isn't fleshed out in terms of the changes to what's expected in terms of statement of facts and grounds, other procedural aspects, I can see that opponents, if they are met with documents that don't conform with procedural arguments, raising complaints with the court and saying, look, we're having to waste our time going through reams and reams of information of stuff that doesn't conform with what was supposed to be a predictable procedure set down in the CPR, and suggesting that that's a basis, if not for excluding claims or whatever, then certainly being reflected in cost awards and things like that. Now, I suppose it depends which judge you get and how aggressive you want to be, whether from claimant side, respondent side, in terms of that sort of conformity with the procedural rules. But I think having laid these down and having said that their function is to be predictable, that parties can expect the courts to stick to them and uphold them, and that would be the way to do it. But it's going to depend. We'll have to just see on what practice emerges from the courts and how robust they're prepared to be, shall we say, in terms of enforcing these. But the shift is towards formalisation, and I don't think we should be surprised if we see parties using that as a stick to beat their opponents with if they don't stick to the rules.
Excellent, thank you. So Charles, final question for you, which is what is a solicitor to do if they're instructed at 11 o'clock on the last day available for the claim? Should they attempt to issue the claim in some form, and what are the risks involved in that? So apart from, I'm sure your advice will be contacting the clerks at FTB to see if you're available to help, but beyond that, what do you think a solicitor in that situation should do?
Well, I mean, I think that it's unfortunate if your client comes to you in those circumstances, but ultimately what you need to do is help your client. Now, in those circumstances, issuing a proper claim in time, I think, is going to be almost impossible. If you think you can do it, then do it. If you can't do it, then I think file a claim form and then make an application for an extension of time to file the statement of facts and grounds with a justification for that. Obviously, that application may not succeed, depends on the reason that your client has given for coming to you at that time of night. I mean, it may be that, in fact, he only discovered the decision was made because it was posted on the council's website at that time and it had been completely hidden before that, in which case he's going to have a very good argument for extending time. But it's probably not going to be possible to drill down into that in the course of a single kind of 6-hour period. So my advice would be bring the claim and indicate that you've not complied with the CPR, and indicate that you will be applying in advance as you are for an extension of time to comply with the CPR, and then deal with it as soon as you can and as fast as you can. And ultimately it will turn on what a judge has to say about it. I think in terms of the approach the court's likely to take to sanctions in that context, I'd say 3 things. The first is that where you've got a meritorious claim, a claim brought a day late is almost never refused an extension of time. Certainly I've acted in cases where solicitors made mistakes about timing, and we've got extensions of time where the claim is 1 or 2 days late. Indeed, in the Mitchell case, the court was very clear that taking bad points about extensions of time is itself likely to result in indemnity costs against the person who takes that bad point. So that's my point 1. The second is that I think, as Sarah says, we are going to see resounding costs orders, failures to comply with procedure. So I don't, for my own part, think that if you put in a 26 or 27 page skeleton argument, the opposing advocate is going to wave their hands too hard about it. I don't think you should do it. But I think that probably the duty to assist the court by both parties means that no one's going to ultimately object to it. But I think when it comes to costs argument, if you try and recover the cost of that 27-page skeleton argument, you are going to be met with, it was an overlong skeleton argument, it didn't comply with the rules, and we should not have to pay for it. And I think judges are going to start punishing people for doing it so that it discourages over lengthy skeletons. So that would be my guess as to how these rules end up playing out in practice.
Excellent. Well, thank you both very much, both for your talks and for the answers to those questions. So we'll draw it to a close now. Thank you to everyone who's kept with us throughout the whole presentation. We've got some more public law webinars coming up soon. The 14th of June to cover public law principles in planning cases, 21st of June on acting for interested parties and intervenors in judicial review, and then on the 1st of July on retained EU law. So hopefully you'll be able to join us for some, if not all of those. Thank you very much indeed. And thank you again, just finally, to Sarah and Charles for their excellent presentations. Thank you.
Thank you, Richard, for looking after us as well.
Thanks, everyone. Have a good day. Enjoy the sunshine and the bank holiday.